It is a privilege for me. It really is a privilege to join with top federal officials, members of the bench and the bar, federal, state, and local law enforcement and corrections officers, jail and prison administrators, victims, prosecutors, former defendants, and advocacy organizations as we examine, discuss, and ultimately work to improve the state of pretrial justice in America. Today, after decades of study, analysis, and cooperation, there's no doubt that compared to Attorney General Kennedy's time, current pretrial release and diversion programs are not only more effective, they are more just. And yet, serious problems as well as significant inefficiencies remain. Across the country, nearly 2/3 of all inmates who crowd our county jails at an annual cost of roughly $9 billion taxpayer dollars are defendants awaiting trial. 2/3 of all inmates are awaiting trial. Now, many of these individuals are nonviolent, non-felony offenders, charged with crimes ranging from petty theft to public drug use. And a disproportionate number of them are poor. Now, the reality is that it doesn't have to be this way. Almost all of these individuals can be released and supervised in their communities and allowed to pursue or maintain employment and participate in educational opportunities and their normal family lives without any risk of endangering their fellow citizens or fleeing from justice.
The crime rate now in the country is what it was about in the mid-1960s in California, where I live part-time. It's where it was in 1958.
Notwithstanding the sharp decline in crime rates, Dr. Austin noted that jail admissions remain high.
12 to 13 million admissions into the system each year. It is where the punishment is being dealt. If you want to punish people and get a large number into that punishment thing, because that's what jails are designed to do, about 1/3 of those 12 million are gone in the first 2 to 3 days. And this is what's important, I think, on pretrial release. If you don't get out of that jail system in 2 to 3 days, you're going to stay for a while. And you're probably going to stay in the neighborhood of, 4 to 6 weeks, 8 or 9 months, depending on what the case looks like. So if you don't get out there quickly, you're going to be staying.
The need for individualized risks and the role played by pretrial services. Symposium speakers addressed the flaws in the pretrial release decision-making practices of many jurisdictions. In most communities, decisions regarding bail are made on the basis of the arrest charge, rather than on an assessment of danger to the community or failure to appear in court posed by the individual defendant.
The fact is, a sound pretrial infrastructure is not just a desirable goal. It's vital to the legitimate system of government and to safer communities. And we need to ensure that the decisions made during the pretrial stage are based not on intuition or custom or a fixed bond schedule, but on determinations of risk and safety that rely on data and individually based assessments. In other words, we need an evidence-based approach to pretrial justice that realizes the system's full potential.
The same week as the symposium, the American Council of Chief Defenders of the National Legal Aid and Defenders Association issued a policy statement calling on criminal justice stakeholders to make a new commitment to help assure fair and effective pretrial release decision-making. Ed Monahan, chair of the council, discussed the challenges public defenders face in assuring pretrial justice, beginning with the initial appearance of the defendant in court.
The problem is, will there be a public defender in the courtroom to make any argument? And if that public defender is there, will they have less than 400 or 500 or 600 cases to be able to make an argument that is based on individual information competently obtained? That's the question.
I think it takes the goodwill of the smart, talented people in this room to make it a priority. I was struck when Tim was speaking about how, a few years ago we would have thought mental health wasn't important, a few years ago, and I thought, it was actually a cultural change. I think race is always uncomfortable for people to think about, and anytime you point out a racial disparity, immediately someone thinks, well, you're calling me a racist. Sometimes that's true, but it is. And sometimes it's not that. It is we are making decisions that are not informed decisions, that are not evidence-based decisions, and they have an impact that we don't anticipate. Sometimes you can see it, and sometimes you have no idea that if I just simply took prior arrests for nonviolent offenses out of the equation, that would drastically reduce the racial impact. If I take marital status or college education out of the equation in terms of whether I release or detain, that would change the calculus. But the numbers are pretty clear in jurisdictions across the country, and it just takes an effort on the part of the administrators to simply say, I'm going to make this a priority, and we're not going to perpetuate these disparities as we move forward with the reform.
Access to justice is our responsibility. Dealing with that issue at the pretrial level of justice is critical to the future of this country.
Judge Truman Morrison urged participants not to forget the right of everyone coming through the criminal justice system to be treated with fairness.
But we need to remember that every time a person is unnecessarily held in a jail cell until their trial, that's an immense human tragedy for that person, their family, and it radiates out into the community. And we should never apologize for, when we're talking about justice policy, for talking about fairness.
More information about the National Symposium and pretrial justice may be found on this website.